one count of misdemeanor disorderly conduct, with the remaining counts in the complaint dismissed and read in, and a joint recommendation by both parties for court costs totaling $443.
And I believe he was in the process of a revocation. Was he revoked or did?
Yes, Your Honor. As of yesterday afternoon, the final decision from the administrator came in, and he has been revoked, and he will be sent to Polk County for sentencing.
Okay. And what charges was he convicted of in Polk County?
I believe they were substance use related, Your Honor. I was not.
Right here, the judge fires off a massive warning shot. Not in the public interest. Translation: the court thinks this plea deal is way too soft for what's being alleged. This is one of those moments where you have to ask yourself, is the system turning a blind eye, or is the state hiding something behind the scenes? And here's the real question. Should a simple disorderly conduct charge ever be used to wrap up allegations tied to a victim's statement? Sound off below. This one demands opinions.
Originally opted into that case. That was my predecessor, Mr. Pollack. Unfortunately, I cannot speak to any detail as to the nature of those charges.
All right, thank you. I can just pull it up. I just am curious. Would it be for the 24 cases or for a 21 case, Mr. Cote?
24?
Oh, 24 case. Okay, so for the 24 cases, possession of amphetamine as a repeater, possession of cocaine, a misdemeanor. What it looks like. All right. Okay. Basis for the agreement and why it's in the public interest, Ms. Rockow?
Your Honor, Mr. Schmidt negotiated this case with Mr. Pollack and Mr. Flasky, but based on my review of the file, I believe that this was based upon the facts and circumstance surrounding the case being relatively minor in terms of the disorderly conduct. There was, of course, the violation of the bail, but that was the Polk County bail. And so it looks like that was all resolved with his latest revocation. So those bail jumps being dismissed and read in is appropriate for that reason. And I don't believe that any additional confinement or supervision is going to be necessary as he is facing that sentence for the revocation.
Okay. All right. So we do have victim SB in the courtroom here today, and Ms. Bauer, SB would like to make a statement. Is that correct?
Yes, Your Honor.
SB may come up here and have a seat at the black desk, and you may provide a statement. If you are going to read something, please read it very slowly so my court reporter can take everything down.
Of course.
I was in a relationship with Andrew Cote for almost a year. Since we started dating on January 22nd, 2024, I knew there was something wrong with the way he would talk to me or even act. But I was in love. On April 5th, that's when the real anger started. Almost every day from then until the 22nd of October, or the 21st of October, there were fights. He would hit me. But he always thought that he could just make it up. Sorry. On October 21st, we were at a friend's house, and he was on the phone with a friend. And just out of nowhere, he called me the B word and then threw a car manual at me. Seconds later, he would spit in my face. But once again, made it up, told me he would never do it again. But just a couple hours later, my world flipped around. On October 22nd, about midnight, we left the friend's house and he drove to a parking area in Grantsport. I ended up falling asleep in the passenger seat, like I always had. He ended up waking me up to ask me where the drugs were. I handed him what he had wanted, and I went back to sleep. He woke me up again and asked me for the other bag. I said I gave him everything I had, and I didn't have anything else. He got angry and started firing the flare gun out the sunroof. The second time he woke me up, he asked me once again, and I told him the same thing I had told him the first time. This time, he got mad at what I had told him, and he ripped off the rearview mirror and threw it in the back seat. Then he took the passenger visor and ripped it off the car, and then hit me in the cheek with it. The third time he asked, I told him the same thing. This time, he ripped off my glasses, bent them, and broke them. So I thought I was going to try and call for help. He ended up taking my phone and with his two hands, literally ripped it in half. The fourth time he woke me up, I kept repeating what I had told him every time. And this time I looked at him and I looked in his eyes and they were black. It was like Andy was gone and someone else took over. The next thing I knew, he started bashing my head against the passenger window. And all I kept thinking was, I have to get away, otherwise he's going to kill me. So I had got him calmed down enough to where he would drive to Dollar General where the van was parked. We were going to move it, but we decided he didn't want to because he was getting tired. He let me drive the car, and I knew that was the only way I was going to get out.
This is the moment the case slams from routine courtroom chatter into something dark and heavy. Listen to how SB lays it out: rising violence, property being smashed, and clear signs of coercive control. These are the kinds of details that, if proven, could ignite far more serious criminal charges. And yet none of this appeared in the complaint the judge reviewed. Unbelievable. This is exactly why victim testimony can flip a case on its head. So here's the real question. When new, damning details surface later, should prosecutors reopen the door to harsher charges? Drop your thoughts below.
I drove the car to the Frederick trailer park, where I knew I would be safe. I parked in the front entrance and stopped. He woke up and started yelling, calling me every name in the book. But I was only able to grab my purse, and that was it. I started walking to my friend Jen's house in the park, and I got there, and she asked me if she could call, and I said yes, and fell to the ground. The cop from town came, and my body started going numb. I ended up throwing up and passing out. Not knowing what was going on, they called the EMTs, and I went to the hospital and had a CT scan. Your Honor, this is so painful for me. I have anxiety and panic attacks now every day. I am actually on nightmare medicine. I don't know the name of it. But I have nightmares every night, every time I sleep, of what he did to me. I am in therapy almost either 1 or 2 days a week, and I will be on therapy for at least 3 years, she said. This was 6 months ago, and yet it still gets to me every day. I don't know how I'm going to move on from this. So I'm asking you for some stipulations. 90 days in jail, no contact with me, my property, or my roommates, no possession of firearms, anger and drug treatment, and probation. I don't think it's fair that I have to live with this every day and he would get away scot-free. He has made it to where I don't feel safe, and I will be putting 2 restraining orders on him for both counties. I can't go outside by myself. I can't go to the store by myself. He's already threatened me enough. Thank you.
Thank you. Just a bit of information. You only need 1 restraining order. It covers you everywhere.
Okay.
So you
Thank
don't
you.
need to go to both counties. Thank you for your statement.
Thank you.
And for the record, and I'm sure that, well, maybe the state had more information, but that's not any of the information that is contained in the criminal complaint. The criminal complaint is very sparse and just indicates that there was an argument and it may have escalated, but what I have access to doesn't discuss the level of what that argument may have been or consisted of. So, all right. So then the agreement, Ms. Rockow, now again, after hearing the victim, what is the basis for the agreement in the justice or in the public interest?
Well, Your Honor, I think some of that information wasn't information that the state had when this case was charged or when this offer was made. It's not my file, but from my review, I didn't happen upon that, what was described just now. So based on the facts that are contained in the criminal complaint.
And again, and I'll state, you're probably hearing or seeing it for the first time as the court is, because the criminal complaint is one small little paragraph that just describes a fight that occurred and that it may have escalated a little, but none of the detail.
Right. But Your Honor, again, Mr. Cothey has been revoked in Polk County on some more serious charges and is going to be presumably serving a jail sentence. I think at least one of those had some state jail time. So I think that he's going to remain in custody for a while. I don't believe that based upon the facts, that anything more is necessary here. I think that the bail jumps, again, were associated with the Polk County cases. So I don't consider that to be, of course, he violated his bond. But I think that the focus here in Burnett County should be the disorderly conducts. And I don't think that any jail or probation is appropriate. I do think that costs only is sufficient to protect the community.
All right. And my guess is that the state wasn't aware of, I'm going to guess also maybe the police were not aware of the extent of the argument or what occurred that night, because otherwise I'm questioning why a battery wasn't charged.
Right. I don't have any information about bruising or pain or injury in the file as I review this.
And he is being revoked, and I'm taking judicial notice of 24 CF 15, 24 CF 224, and 24 CF 310 Polk County matters, in which he has now been revoked on those matters and will go face sentencing in Polk County. I believe in those cases, there is no state jail time. That was that fictitious thing that some judges do, and they fictitiously say, I'm having that fictitious conditional jail for probation to use if they wish to do. And so with regards to with regards to the charges in Polk, he does have the possession of amphetamine with the repeater. So that means the maximum possible penalty of 1 year he could face, with the increase of no more than 2 years for that underlying misdemeanor in Polk County. But that's for Polk County to deal with and for you to deal with in Polk County. And you were under bond conditions in Polk County when you violated your bond here by engaging in the criminal actions here in Burnett County. And for the record, and this is, I guess, for the victim as well as you, Mr. Cote, for you to be aware of, and perhaps the reason why these were simply charged as disorderly conducts is because of the little bit of information that was provided the day of the incident, at least that I have in front of me. And usually what's in the criminal complaint is what has been provided to the police in the police report. So there's not much. This is the first time that I believe perhaps even the state is hearing the depth of what may have occurred that night. So he's pleading guilty to 1 count of disorderly conduct, is that correct? And the other count will be dismissed and read in, and he's facing the other charges in the bail jumps in Polk County?
To my understanding, Your Honor, that is correct. It's a plea for 1 count of disorderly conduct, with the remaining counts in the complaint to be dismissed and read in. As has been stated, he is currently he has been revoked from probation, and he will be sent to Polk County for sentencing after revocation. I would like to take note that he has been in custody on this revocation hold stemming from this incident since October 31st of 2024. He has accumulated approximately 155 days of jail credit. The conduct has again prompted revocation here, in the maximum sentence for a charge of disorderly conduct has been vastly exceeded. It's he's set for close to double the amount of time he would for the maximum sentence on this. The public, I believe, has been sufficiently protected. He will continue to reside in custody, awaiting sentencing after revocation. I believe he will be returning to active supervision for his Polk County charges as well. In entering this plea, he is taking accountability for this and does wish to move on. For those reasons, I would ask the court to adopt the joint recommendation. Thank you.
All right, can I have the plea questionnaire waiver of rights form, please?
Yes, Your Honor. May I approach?
You may. So I have in front of me the plea questionnaire waiver of rights form. Mr. Cote, did your attorney go over this document with you thoroughly?
Yes, Your Honor.
Did he go over it word for word?
Yes, Your Honor.
And do you understand it completely?
Yes, Your Honor.
If you didn't understand it, did you ask him to explain it?
Yes.
And he did so?
Yes, Your Honor.
So you're 37 years old, you have 12 years of schooling, you can read, write, you understand the English language.
Yes, Your Honor.
That's your signature on the second page.
Yes, Your Honor.
You're pleading guilty to 1 count of disorderly conduct, is that correct?
Yes, Your Honor.
Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes, Your Honor.
Did your attorney go over with you the maximum possible penalties you face?
Yes, Your Honor.
No mental illness or disorder, and no alcohol, medications, or drugs?
No, Your Honor.
Because you're charged with crimes, you are entitled to constitutional rights, and each of these rights is listed on this document. Did your attorney thoroughly go over these rights with you?
Yes, Your Honor.
Do you understand them completely?
Yes, Your Honor.
Do you understand that by pleading guilty, you're waiving and giving up these rights?
Yes, Your Honor.
Do you need me to go over these rights with you in any more detail?
No, Your Honor.
You understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, Your Honor.
You understand the state would have to prove on or around October 21st, 2024 in Burnett County, Wisconsin, while in a private place you engaged in indecent, boisterous, abusive, and otherwise disorderly conduct, which under the circumstances did tend to provoke a disturbance. Do you understand what the state would have to prove?
Yes, Your Honor.
Do you understand the maximum possible penalty? The maximum possible penalty of this crime could be a fine of up to $1,000 or up to 90 days of incarceration, or both. Do you understand that?
Yes, Your Honor.
Do you also understand I have a recommendation from both of the counsels, both of the attorneys here, a joint recommendation for costs only. That would be court costs and DNA surcharge, etc. Costs only for $443. Do you understand that is simply a recommendation to the court?
Yes, sir.
Said differently, that means I'm not bound to follow that, and I could sentence you all the way up to the maximum possible penalty, and I could do that here today if I thought it was necessary and warranted. Do you understand that?
Yes, sir.
Do you still wish to proceed and enter a guilty plea?
Yes, sir.
Did you go over the criminal complaint with your attorney?
Yes, sir.
And again, that's that document that basically says what happened that day and why you were charged with the crime. And albeit it is very short and it doesn't have a lot of facts and it doesn't have as many statements or factual assertions as the victim did state here today, but as it's stated in the probable cause section of that criminal complaint, for the most part, are those facts accurate?
Yes, sir.
Did you get into an argument and into a fight with SB?
I don't believe so.
You don't think you did?
I just know that when she dropped me off, she was yelling stuff at me when I drove off.
So what did you do?
I just drove off.
You didn't do anything?
No.
You didn't provoke a disturbance?
No.
Good, we're going to trial. Thanks. We'll set this matter for...
And that is a full-blown plot twist. The defendant just torched the plea deal by denying the very facts he agreed to plead guilty to, instantly forcing the judge's hand. If the facts don't line up, the judge cannot accept the plea. Basic legal reality. You can't plead guilty to something you claim you didn't do. So now everything detonates. This case is charging straight into trial, and the stakes just went from high to sky high. What's your call? Conviction? A desperate last-minute plea? Or is this whole case about to explode and fall apart?
Okay. Sounds like we're going to have a trial on 2 disorderly conducts and 2 bail jumps. That sounds good to me. So maximum possible penalty for 2 disorderly conducts, up to 90 days of incarceration, and for 2 bail jumps, up to 9 months each. Because if you're indicating you didn't do it and you're indicating that you're innocent, by golly, the state has to prove beyond a reasonable doubt. And so I think we're going to set the matter for trial, and I think we need 1 day. Let's set it for trial here today, Miss Rockow. Is this going to be a your case, or is this going to be a Mr. Schmidt case?
This is Mr. Schmidt's case.
Okay, let's get the matter set for trial, and we can do it. I can presume you're going to be in custody for a while, since you are revoked on your Polk County matters. But we don't have a problem getting you back here for a trial. We have a really great lieutenant who runs our jail very well, and we have the ability to do transport. So let's get this matter set, and let's get it set for sometime soon. And we have the victim here, so we can make sure that we have a date that works for the victim as well. How about June 24th? It is on the assistance week, but June 24th sounds like a good day to have a trial. How does that work for you, Mr. Flisky?
I'm available that day, Your Honor.
Excellent. So we'll have a trial on June 24th. That'll be a trial because, again, if you didn't do anything that day, that's what your assertion is here, Mr. Colte. The state has to prove it beyond a reasonable doubt that you engaged in any type of conduct that would be disorderly, and whether or not you were on a bond in Polk County and whether or not you violated that bond, and you did so knowingly. So that's what we're going to do. June 24th, we will have a trial. We only need 1 day. That works for victim, Ms. Bauer?
Yes, sir.
Excellent. Now let's get to my final drop dead date. That means, Mr. Colte, that is the day that I will no longer take any type of agreement, okay? I won't accept any agreement in this case, all right? And so that means the matter will go to trial, and you will be able to have your attorney state your, or actually have it'll be the state trying to prove the case, and your attorney will be able to defend you and your claims at this matter. But on May 29th, that'll be the last day, the drop dead date for any agreement that'll be reached. And quite honestly, to me, the court does not find a disorderly conduct with costs only especially hearing the statement from the victim to be in the public interest. So let's do May 29th, Mr. Feliski, May 29th. Well, you said that this is going to be a Schmidt, even though it's on that. So let's do May 19th, drop dead date. May 19th, can you do 10:45?
Yes, Your Honor.
All right, May 19th at 10:45, we're going to have our drop dead date for any agreement that can be reached in this matter. Otherwise, we will go to trial. We don't have to worry about lab. We have confirmation that victim will be able to be present in here for the trial. We're good to go. All right. Thank you. We're adjourned. We'll see you then.